Good evening. Hello, everybody. Hello. Welcome in. Welcome in. Hello, hello, hello. Wow, we've had a lot of lives this week. Hello. Welcome. 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 Hi, Thomas. Hello. Good evening. Good evening. Hi, James. Hello. Welcome. Welcome in, everybody. We have had a lot going on this week for sure. Just a lot going on. Yes, we have. Oh, thanks, Robert. Well, welcome in, everyone. I had not expected to be back on again until later this week, but surprise, surprise, here we are with the new DC indictment. So exciting. Hello, hello. Make treason wrong again. Oh my gosh. Oh, I love it. I love it. I love it. Put it on a t-shirt. Let's get it on a t-shirt. Somebody tell Hawk. Hello, 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 everybody. Oh, I know, Steffi. I know. So I was not expecting a superseding indictment, although I suppose I should have been. Jack is not shy of filing his superseding indictments, and as was shown in Florida, and so here we have it in DC as well. So patiently waiting. Oh, thanks. Yes, I was very excited to get on. How are my spoons today? They're all right. They're dwindling. So I'm glad I can hop on while I can. So yes, we've got the new indictment tonight. We do have a superseding indictment. He has been busy. You know what's so great about a superseding indictment, also, everyone, and a friendly reminder, is that it involves another grand jury. So another grand jury has been pulled in yet again in DC in order to hear the evidence put on. So yes, Jack's been very busy. Best hands on TikTok. Oh, that's so sweet of you to say. Oh, thanks. Oh, Chasing Oz called it a couple weeks ago that he would. Yes, I think it's great. Yes, I am having a very lovely day. Thank you very much, Deborah. Appreciate that. Yes, I'm starting to get my fall nails out, everyone. So the season's changing, and I think it's time. My nails will be changing also. Yes, saving a spoon, absolutely. I saved a couple, so we'll see how things go. We won't be on for too long tonight, but we will take some time to go through this. Love the sapphire. Oh, thanks. Hey, the captain. Yes. Oh my goodness gracious. We're gonna hit the highlights tonight, everyone. But wow, yeah, pretty big news. Pretty big news. Yes, I've got a flannel. I know, but I hadn't planned to come on tonight, everyone. I just could not get out the dress shirt, so I got the flannel going. No white nails after Labor Day. That's hilarious. I do have some white ones actually. So hello, Murray. Welcome in, everybody. All right, so welcome everyone, welcome. We have a brand new superseding indictment out of DC. Now, this week, yesterday, we had gotten news on the Florida case. We had seen a brief filed by Jack Smith's team in Florida, and by the end of this week, we were going to hear an update on the status of the case in DC. But in the interim, Jack went ahead and filed a superseding indictment here, so very exciting. He went ahead and set this out. Now, a superseding indictment means, again, that we've pulled another grand jury in and the evidence has been presented and they've come back and agreed to the indictment. So I think the best way to really go through the superseding indictment, this is the original indictment out of DC. So we have our 4 counts set out here. And again, the DC case is the only case where Mr. Trump is the only defendant. And so we've still got the same 4 counts in the new one. So what I've done is I've gone through and a lot of the language in that first indictment is still in this superseding indictment, but we have changed some things. We've removed a few things, and what I think Jack Smith's team has done is try to put this in a format that fits with the immunity case that was decided by the Supreme Court that first week in July. So I think what he's done is kind of reworked the language and kind of cut some things and added some things in order to accommodate that new decision. So this indictment, I believe, is fully in compliance with the immunity decision. Oh, thank you so much. Oh my goodness, John. Oh, wow, lovely. Oh, absolutely, Professional Spoonie. Happy to do it. Happy to do it. So, with the immunity decision, everyone, that came out, just as a friendly reminder, we had this question of if it's within the scope of official duties or the official responsibilities, the official role of the president versus unofficial, private, or the campaign candidate as opposed to the president himself. So after going through and looking at that decision, what Jack's team's done here is trimmed away the language and kind of shifted some of the language to be in compliance with that Supreme Court decision. So that's really what this indictment's about. The superseding indictment is not adding any new counts here. They're not adding any new charges. But what they've done is reworked the language so that it is within the scope of that new Supreme Court decision, which I think is just a great, great job. So the heaviest crime violation, right. So we've got conspiracy to defraud the United States, conspiracy to obstruct an official proceeding, obstruction of an attempt to obstruct an official proceeding. And these were the two big ones regarding the false elector scheme. And then the last one here is count 4, which is conspiracy against rights. So each of these is pretty significant. Of course, a conspiracy charge means that 2 or more people were involved and substantial steps were taken in order to commit an offense rather than the offense itself. And counts 3 and 4 are, or counts 3 here is an obstruction count. So we do have lots of that. Oh, great, Brian. Love to hear it. Love to hear it. So again, as I go through, what I will do is show you what's different between the two indictments, all right? We don't have brand new charges. We don't have new defendants. What we have is a change of language and we have a different setup now based off of that immunity decision. Now, one of the things that we should always remember is that as attorneys, no matter what decision we get from the U.S. Supreme Court, you know, our job is very much like Ross's job when moving a couch, which is to pivot. And we're doing that a lot. And there's a lot of movement here to change this language from any kind of official conduct by Mr. Trump to conduct by candidate Trump, which is falling further in line with the Blessing Game case, which is a civil case out of DC that is the civil partner to this case. And a lot of that has been shifted here. So I think they've done a good job. JD Vance, now that's not true. That's just not true. I don't know. I don't know anything about that. I don't know anything about that. But we are having to pivot here because we have a Supreme Court decision that's come down. All right. So welcome in, everybody. I will not be reading every single word line by line here because it's just really not necessary in order to understand where the big changes have been here. So here we go. Welcome in. I will leave comments on tonight, everybody, because I will be kind of shifting between the language here in the superseding indictment and questions and comments that are coming in. So we'll kind of be shifting between the two of them. All right. Well, welcome in. What's happening in Texas? Oh, Navy vet. No. Is there more happening in Texas? There's so much going on. You'll have to tell me. Okay, we're ready. All right, John, we're ready. I love the nails. Oh, thank you. Yes, we're switching to fall. So we love when you trim it down. Thanks, Desert Skies. I do have a Tube of You channel. I do. Quite a bit of my posts are on there. All right, everyone. So here we go. Here's the original set out. This was filed August 1st of 2023, a year ago. So we've got counts 1, 2, 3, and 4. And under the indictment, we have an introduction here. So again, I will just take you through the original and the superseding and explain kind of what's been changed. So each paragraph is numbered in both indictments, and that's just a way to refer to it when we're referring to it in any of our hearings or any of our other documents. We'll refer to it as a number. So number 3 has been cut. So that's our first cut. And I think it's important again because this whole situation is trying to make sure we're in compliance with that Supreme Court's decision. So here's the superseding indictment. We have 1 and 2, and then now we have a different number 3. So with number 3 cut, let's see what they have added in the superseding indictment here. 12 people to 20, it depends on the jurisdiction, and I do not remember the exact number that is needed in the DC circuit. I'm assuming it would be 12, but that would be a Google moment for everyone. So, but yes, whichever jurisdiction you're in will set out the grand jury requirements. So here, this one, number 3, has been added. So number 3, as a candidate and a citizen. All right, this is key language that's been added to this new indictment. The defendant had a right, like every American, to speak publicly about the election and even to claim falsely that there had been outcome determinative fraud during the election that he had won. He was also entitled to formally challenge the results of the election through lawful and appropriate means, such as by seeking recounts or audits of the popular vote in states or filing lawsuits challenging ballots and procedures. Indeed, in many cases, the defendant did pursue these methods of contesting the election results. His efforts to change the outcome in any state through recounts, audits, and legal challenges were uniformly unsuccessful. So this is what has been added now in the superseding indictment, and paragraph 3 has been cut from the original. So again, I will be going back and forth to just show you what's been added and what's been taken out. So here we're back in the original indictment. Number 4 is the same, setting out here what happened right after the election day. Thank you, Eleanor. And then count number 1 is set out. Now, count number 1, we have just a little bit of an addition here right before we hit count number 1 in the superseding indictment. So you're going to have to, because I will be hopping through through both of them, I'll try to keep you up to date here. But number 5 was added in the superseding indictment. So this one's new. In furtherance of these conspiracies, the defendant tried but failed to enlist the vice president, who was also the defendant's running mate, and by virtue of the Constitution, the president of the Senate, who plays a ceremonial role in the January 6th certification proceeding. So this was added, and I think it was added because we have this element of the vice president that again was put into play because of that immunity decision. All right, everyone. So number 5 was added. Now, if we take a look here, we've got count number 1, conspiracy to defraud the United States, and it is the same here. We've got them set out, the conspiracy. The date was changed. I think there was a date issue here. And we've got from on or about November 13th of 2020 through on or about January 20th of 2021 in the District of Columbia and elsewhere, the defendant, Donald Trump, did knowingly combine, conspire, confederate, and agree with co-conspirators, known and unknown to the grand jury, to defraud the United States by using dishonesty, fraud, and deceit to impair, obstruct, and defeat the lawful federal government function by which the results of the presidential election are collected, counted, and certified by the federal government. So this language is the same here in the superseding indictment. So looking back at that first indictment, the original indictment, the purpose of the conspiracy is the same. Now, something that's new in the superseding indictment are the defendant's co-conspirators. If everyone remembers, when our indictment first came out, we were all kind of thinking, ooh, who are all of the co-conspirators? Well, one of the co-conspirators has been cut from this, from the superseding indictment. And also the language has been changed a little bit. So let's take a look here. So originally, in the original indictment, we had all the way through F on our co-conspirators, through co-conspirator 6. We now only have co-conspirators set up this way. Number 4 has been removed. They kept their original numbers to make the indictment clean, but we've got 1, 2, 3, 5, and 6. So co-conspirator number 4 has been removed. So let's take a look here at our co-conspirators, how this has been reworded. Yes, that's right. So we've got the defendant enlisted co-conspirators to assist him in his criminal efforts to overturn the legitimate results of the 2020 presidential election and retain power. These co-conspirators included the following individuals, none of whom were government officials during the conspiracies, and all of whom were acting in a private capacity. So this paragraph is new. So originally, everyone, we had A, co-conspirator 1, an attorney who was willing to spread knowingly false claims and pursue strategies that defendants' 2020 re-election campaign attorneys would not. I'm going to be moving too quick, Desert Skies, to be able to put in a sticky note on this. I'm just hopping around too much. So hopefully if people will catch that this is the new indictment, I'm hoping here. We've got a B, the co-conspirator 2, but what we've lost has been co-conspirator number 4. So let me explain here. Co-conspirator number 4 has been eliminated from this new indictment. All right. Co-conspirator number 4, a Justice Department official who worked on civil matters and who, with the defendant, attempted to use the Justice Department to open sham election crime investigations and influence state legislatures with knowingly false claims of election fraud. So this co-conspirator has been dropped, all right? So that's probably the first major change that we'll see here in the indictment. Number 4 has been removed. So again, they've kept their original numbers, so these are the original people, but number 4 has been taken out. Jeffrey Clark, yeah, it's Jeffrey Clark. Jeffrey Clark, who worked for the Justice Department. And what you'll see here is that they're very careful now about the language with the Justice Department, again, because of that immunity decision. So Jeffrey Clark's been pulled. Has he flipped? Great question. And the word on the street is that, yes, he flipped quite a bit. So they certainly don't need him anymore. And in order to not deal with any of the immunity questions, they just completely pulled him from the indictment. All right, everybody. So he's out. All right. So the next piece, the federal government function, is the same on page 4 of the new indictment. Again, I'm going through both indictments here. This is the superseding indictment and the original, and just showing you what is different here. Mark Meadows flipped. Yeah, could be. I feel like there's a lot of flipping going on, although Mark Meadows is still fighting the good fight down in Georgia. So he must not have flipped in Georgia, at least. Next, we have manner and means set out. Defendant's conspiracy to impair, obstruct, and defeat the federal government function through dishonesty, fraud, and deceit included the following manner and means. Again, this is the superseding indictment. This language is exactly the same as the original indictment. So we will flip the page here, and until we get to the first piece that's been changed, we had one paragraph cut. So this paragraph here from the original indictment has been removed. So this has been cut. Let me go ahead and read this to you so you can hear what has been removed. The defendant and co-conspirators attempted to use the power and authority of the Justice Department to conduct sham election crime investigations and to send a letter to the targeted states that falsely claimed that the Justice Department had identified significant concerns that may have impacted the election outcome. that sought to advance the defendant's fraudulent elector plan by using the Justice Department's authority to falsely present the fraudulent electors as valid alternatives to the legitimate electors, and that urged on behalf of the Justice Department the targeted states' legislatures to convene to create the opportunity to choose the fraudulent electors over the legitimate electors. So this paragraph has been removed from the superseding indictment. Yes, Jenna Ellis as well. So again, the rest of these paragraphs are the same, but when we're talking about the Justice Department, it has been removed here. So next up, we've got the defendant's knowledge of the falsity of his election fraud claims. And we've had some pretty big cuts made here. So let me take you through this language. And you can see I've made notes where there have been some big changes made. So this particular paragraph has been reworded. So let me go ahead and read the new paragraph. All right, so here's the new one. Throughout the conspiracies, the defendant, co-conspirators, and their agents made knowingly false claims that there had been outcome determinative fraud in the 2020 presidential election. These fraud claims were unsupported, objectively unreasonable, and ever-changing, and the defendant and co-conspirators repeated them even after they were publicly disproven. These prolific lies about election fraud included dozens of specific claims that there had been substantial fraud in certain states, such as large numbers of dead, non-resident, non-citizen, or otherwise ineligible voters had cast ballots, or that voting machines had changed votes for the defendant to votes to Biden. These claims were false, and the defendant knew that they were false. So that paragraph's just kind of been reworked a little bit. So just to kind of keep you up to date on all of that. Again, I'm just comparing everybody, the original to the new one here. All right, so let me make sure I've got the same paragraph. So for 13, and then hold on here a second, everybody. It is difficult because all of the numbers changed as well. So it is a bit difficult. So we've got here, we've got defendant's knowledge of the falsity of his election fraud, and then we have a new paragraph. So defendant's knowledge of election fraud, and then new paragraph here. And then the manner and means is new. So what has happened then is that all of this part has been cut from the previous indictment. All right. So I'm trying to be as clear as I can be. Is everybody following me? Okay. It's kind of hard to show you the two documents here, but I'm just showing you what's been cut and what's been added. So I'm hoping this is clear enough for everybody. All right, so we've had multiple pieces. Yes, perfect. Okay, great. Thank you so much. I appreciate that. So manner and means is next. So let me show you what's been cut. Primarily, we've got the defendant's vice president information, the senior leaders in the Justice Department, Director of National Intelligence, the Department of Homeland Security, Cybersecurity, senior White House attorneys, all of these different pieces where they were explaining to Mr. Trump that his information was false. This has all been cut now from the superseding indictment. They removed all of this information because the immunity decision said that information is privileged. So again, we have senior staffers here for the re-election campaign, state legislators here, state and federal courts here. So that language has all been removed. So just to kind of keep you going here. So manner and means is the next piece that we've got going on. Let me just move forward here to the next part that was the big change. All right, so everyone's following me. Anything that had to do with that kind of information given to Trump as the president, that was removed. All right, still plenty. Oh yeah, there's so much information. All right, so the next category, everyone, the criminal agreement and acts to affect the object of the conspiracy. So this is again the superseding indictment. This is the original indictment. So this is the section here, right? The criminal agreement enacts to affect the object of the conspiracy. And we've got an addition to number 16 here. To affect the object of the conspiracy, the defendant and co-conspirators committed one or more of the acts set below. And then we have the defendant's use of deceit to get state officials to subvert the legitimate election results and change electoral votes. So that is the first subheading, and you can see that is the same subheading in the original indictment, and then the next paragraph is the same. So shortly after Election Day in the original indictment, and then shortly after Election Day in the superseding indictment. All right, so then we flip to Arizona, and we have paragraph 18 is the same in the superseding indictment. 19 is the same as well. And then, let me just make sure this one's out of the way. So we're on page 8 here. So 18 and 19 are the same. And our subparagraphs, these are the same in the superseding indictment. And paragraph 20 is the same. All right, so everyone following me? Here's the original indictment. Here's our subparagraphs. They're all the same. And then moving on to paragraph 20. Then when we get to the next paragraph, we have December 4th, the Arizona House, and then our subparagraphs. Those are also the same as the original indictment here. All right. So let's flip those. The real big piece that's changed is coming up, and I will be reading the big changes, everyone, but I just want to show you what's been changed when it comes to these other pieces. So this is all the same. This is all the same as well. Now, some little changes throughout the entire indictment has been, rather than in, they just say the speech, they are calling it now his campaign speech. Now, a lot of people may not notice this difference, but this word was not in the original indictment. The reason why they're using this language now is because of the Blessing Game case, as well as that immunity decision by the Supreme Court, because they're clarifying this wasn't political speech, this was a campaign speech. So they're clarifying that throughout this entire new superseding indictment. Tea break. Thank you. Thank you very much. Categorizes it as personal. Exactly right. Exactly right. Because if it's personal, then there's no immunity. Immunity is not going to come in. Right? So anywhere we're seeing this change in language to campaign speech is where Jack's team has gone in and said, well, we need to change this up so we can use this information. All right? So that's been changed. And then we go into Georgia in the new indictment. So this little intro piece has been added. It's not really that significant, but we have, again, this information regarding defendant's senior campaign advisor. So this, bringing it back to the campaign information, that was added. And then the next paragraph is the same in the original indictment. So that is the same. Again, here's the original indictment here. And just a couple of little small changes again with this kind of speech. A campaign attorney here has been added. If you look on the original indictment, it just says an agent of the defendant and co-conspirators. Here, it says a campaign attorney and an agent of the defendant and co-conspirators. So it's these little changes here that are making huge differences in order to come into compliance with that Supreme Court decision. All right, so if everyone's hopefully following me down that road that we're going down. So number 27 here, this paragraph is the same. Then on December 4th, this paragraph is the same. And for those of you following on the original indictment, paragraph 28 of the superseding is paragraph 23 of the original. we'll flip this over. And then we've got December 8th is the same, but we've added half of a paragraph here. So let me read to you what has been added. So this number 29 has been added, this information. All right. On December 8th, the defendant called the Georgia Attorney General to pressure him to support an election lawsuit filed in the Supreme Court by another state's Attorney General, which sought to invalidate election results in certain targeted states like Pennsylvania. The Georgia Attorney General told the defendant that officials had investigated various claims of election fraud in the state, including the State Farm Arena allegations, and were not seeing evidence to support him. The following day, represented by co-conspirator 2, the defendant, not as president, but in his capacity as a candidate for office, moved to intervene and join the state attorney general's lawsuit. And on December 11th, the Supreme Court denied the suit. So that's some pretty obvious language. Again, that was added. That is not the same language that is in the original indictment, which would have been here. All right. So, all right. Now, number 30 is the same. Number 31 is the same. And we'll just keep on moving forward here. We had a cut to... let me make sure I've got the right dates that were cut out here. So we have 31, which was December 10th here. And then we had 31 and then 32. So on December 31st. All right, so paragraph 27, 28, and 29 were cut. All right, so from the original indictment, they removed these 3 paragraphs. All right, so first we've got December 15th, the defendant summoned the incoming acting attorney general and incoming acting deputy attorney general and others to the Oval Office to discuss allegations of election fraud. During the meeting, the Justice Department officials specifically refuted the defendant's claims about State Farm Arena, explaining to him that the activity shown on the tape of co-conspirator 1 was benign. So this paragraph has been cut. And again, because we have this immunity decision. On December 23rd, a day after, the defendant's chief of staff personally observed the signature verification process at the Cobb County Civic Center, notified the defendant that the state election officials were conducting themselves in an exemplary fashion and would find fraud if it existed. The defendant tweeted that the Georgia officials administering the signature verification process were trying to hide evidence of election fraud and were terrible people. This has also now been cut, which is basically what the Supreme Court said they wanted to see happen. Next, we had in a phone call on December 27th, the defendant spoke with the acting attorney general and acting deputy attorney general. During the call, the defendant again pressed the unfounded claims regarding the State Farm Arena, and the 2 top Justice Department officials again rebutted the allegations. Telling him that the Justice Department had reviewed videotape and interviewed witnesses and had not identified any suspicious conduct. So this also was cut. So those 3 paragraphs dealing specifically with the Justice Department and Mr. Trump talking with the Justice Department, those paragraphs have been cut, again, in order to stay in alignment here. So then we move on to 32, which picks right back up where we left off. So on December 31st here and on December 31st there. All right, so, and then this one's the same. This paragraph's the same in the superseding indictment. Subparagraph here is the same. And each of these paragraphs are all the same as well. Paragraph number 34 is the same as 32, so that has been kept in its entirety as well. And then this one was added again. We're adding this term campaign speech in his campaign speech, so this language is added. And then we have the first paragraph in the original indictment under Michigan has been removed. So let's take a look at that. Again, is everyone following me okay? I'm really bouncing back and forth between the two indictments. Are you all catching this all right? Right. I'm hoping I'm making it clear enough by just explaining what's been cut and what's been added. Okay, good. Thank you. Just making sure. All right, appreciate that. Just making sure. All right, everyone. So this paragraph has been cut. 34. So on November 5th of 2020, the defendant claimed that there had been a suspicious dump of votes, purportedly illegitimate ballots, stating, in Detroit, there were hours of unexplained delay in delivering many of the votes for counting. The final batch did not arrive until 4 in the morning, and even though the polls closed at 8 o'clock, so they brought it in, and the batches came in and nobody knew where they came from. This paragraph has been cut from the superseding indictment, all right? And then that takes us to the first piece under Michigan, which is number 36. This is the same. This is also the same. And then we have December 4th as the next paragraph, which is showing we had 2 paragraphs cut as well. So let me read you the next 2 paragraphs that were removed. Excuse me. Lies. Oh, Lisa. Yes, there you go. There you go. All right, on December 1st, the defendant raised his Michigan vote dump claim with the Attorney General, who responded that what had occurred in Michigan had been a normal vote counting process and that there was no indication of fraud in Detroit. This has been cut. So I'm thinking again, it's because the defendant is talking to Michigan and they could argue, as the president, he was talking. So they just cut it out. They don't need it. They just cut it and that's fine. So here's number 37 from the original indictment was also cut. Despite this, the next day, the defendant made a knowingly false statement that in Michigan at 6:31 in the morning, a vote dump of 149,772 votes came in unexpectedly. We were winning by a lot. That batch was received in horror. Nobody knows anything about it. It's corrupt. Detroit is corrupt. I have a lot of friends in Detroit. They know it, but Detroit is totally corrupt. So this paragraph has been removed as well. All right, so that's been moved. Yes, I'll put this up on my tube of you. Yep, absolutely. This will be going up as soon as I can get it up after we finish up here. All right, so those paragraphs have been cut, again, probably because those were phone calls made, and it could be argued if they were made as president or as a campaign candidate, personal or professional, we don't know. All right, so next up for December 4th, this paragraph is the same as in the original indictment. Then this paragraph is also the same, number 38, and then number 39, along with this quote from the Michigan House Speaker. That language is all the same as the original. And then we've got number 40 again is different because we've added this language in his campaign speech, all right? And this is right before the Pennsylvania piece. Now, Pennsylvania's part is all the same. Every paragraph in Pennsylvania remains the same here. Nothing was changed other than a couple of little changes like, in his campaign speech. So some of that is the only changes that we'll see here in the Pennsylvania portion. All right, so keep moving on here. We've got Wisconsin. Now, Wisconsin's really the place where our fake elector scheme started, so we had to have a little bit of language change in here. We've got Wisconsin. This one's the same. This is the same. This is the same. And then we have, let's see, December 21st, and then this is number 50. So paragraph number 51 has been cut. So that's the only big change here. So let's take a look at paragraph 51. Again, this has been removed. On December 27th, the defendant raised with the acting attorney general and acting deputy attorney general a specific fraud claim that there had been more votes than voters in Wisconsin. The acting deputy attorney general informed the defendant that the claim was false. So again, I think it's because we've got a discussion between the defendant and the attorney general. This information could potentially be kept out as evidence because of the evidence rule that they put into place after the immunity decision. So this paragraph number 51 has been removed. All right, that's the next one that was pulled. So next up, we've got the defendant's use of dishonesty, fraud, and deceit to organize fraudulent slates of electors and cause them to transmit false certificates to Congress. That's the same here. And then number 50, language is the same, but this last sentence was added. The defendant had no official responsibilities related to the convening of legitimate electors or their signing and mailing of their certificates of vote. So this sentence was added, which you can hear obviously is just to correspond to that Supreme Court decision. All right, so there you go. I thought that was a pretty well written sentence. So what Jack's done here, everyone, and what I'm trying to kind of illustrate is that we didn't need to come slamming through here with a brand new start at the beginning kind of superseding indictment. What he's done is he's taken a scalpel and he has just removed little pieces and added little pieces back to put everything into compliance with the Supreme Court. And I think he's done a really great job. Exactly right. I think his team has done an amazing job here. So this paragraph's the same. This one is the same. Again, for those following along, it was also a new grand jury. Exactly right. So we don't even have any questions of, the original grand jury. Nope, we had a brand new grand jury here. This one was the same, and paragraph 52 is the same, 53 is the same. This one is also the same as well. And these are the same paragraphs as the original indictment. If you are wanting to know where we're at on the original indictment, number 57 in the superseding indictment is number 60 in the original. When you're looking that up, all right, so that's the same, following along at home. 22, we've got, this one is the same, this one's the same. The only difference here is a couple of things, just the language, a few words were changed here and there. So without any big impact, I think just to make it sound better, they made a little change there. So page 23, everything here is also the same. Again, if you're wondering, paragraph 63 is the same as paragraph 66 in the original indictment. Yeah, Jack's done he and his team have done a really great job. Because in the end, I mean, there's no reason to kind of, make a big, huge mess out of it. If the Supreme Court's wanting to be the way that they're wanting to be, then you just accommodate that. There's no reason to make it into a big deal, I guess, is how I think of it. So this paragraph's the same. 65 is the same. 66 is the same, and down this paragraph as well. Now, when we get to defendant's attempt to enlist the vice president to fraudulently alter the election results of the January 6th certification proceeding, now we have to be careful again, right? Because in the decision, the Supreme Court said that there is this kind of discussion between the president and the vice president, and that can't be hampered in any way. So they had to be very careful about how they present the language, the conversations between Pence and Trump. So this language has been changed and moved around quite a bit. So, but we also, though, this is a really big, important piece of the case. So we, of course, had to keep it in. So let me just read this section because it really is almost all completely reworded in order to be in compliance with that immunity case. It's just a few paragraphs, so let me go ahead and read it to you here. Thank you so much. Oh, you're welcome. You're welcome. All right, so here we go. As of January 6th, congressional certification proceeding approached, and his other efforts to impair, obstruct, and defeat the federal government function failed. The defendant sought to enlist the vice president to assist in the plan to use his role as president of the Senate to fraudulently alter election results. Again, this is new language in the superseding indictment. The defendant had no official responsibilities related to the certification proceeding, but he did have a personal interest as a candidate to being named the winner of the election. All of the conversations between the defendant and vice president described below focused on the defendant maintaining power. When his efforts to use the vice president's role as president of the Senate failed, the defendant attempted to use a crowd of supporters that he had gathered in Washington, D.C. to pressure the vice president to fraudulently alter election results. All right, so that's some pretty significant change in language here. Next, on December 19th, after cultivating widespread anger and resentment for weeks with his knowingly false claims of election fraud, the defendant urged his supporters to travel to Washington on the day of the certification proceeding, tweeting, "Big protest in D.C. on January 6th, be there, will be wild." Throughout late December and early January, the defendant repeatedly urged his supporters to come to Washington for January 6th. So it continues on more in that kind of vein. So we've got 4 paragraphs here that were kind of restructured here. And when we look to the original indictment, what you'll see is that we had a whole bunch that were cut. Oh, thank you so much. So paragraph 70, 71, 72, we had about 20 paragraphs cut from this section here. So when he's talking about the attempt to use the Justice Department and what happened with the Justice Department, all of this information has been cut. The December 28th co-conspirator number 4 that was removed, this has all also been removed. All right, everyone, you following me here? So this was pretty significant changes. So we went from, and again, we went from having all of this information regarding our Justice Department into having most of that cut out here. All right, so let's get to page 94. So paragraph 77 here is now paragraph 94. And again, these are all of the paragraphs that have been removed. All right, so anything that had to do with the Justice Department and any kind of conversations that he had with Pence outside of what I just went through have been removed. All right, so there we go. Let's jump back in. So the next part in the superseding indictment, also on January 4th, when co-conspirator 2 acknowledged to the senior advisor no court would support his proposal, right? And that gets us back into the original indictment here. All right. All right, so 94, 95, 96, in case you're wanting to match up where the indictments go again. So just so that everybody remembers here, we've got about 3 pages of the original indictment that have been cut. All right, so I'm not reading through word for word, but we have the vice president's call on the 25th, the contemporaneous notes that were kept by the vice president, how he berated the vice president, all of that information, and that has all been removed in the superseding indictment. All right, so here we go. Then we're into paragraph 96, which is the same now. 97 is the same. And 1 paragraph was cut here. The paragraph that was cut is this one, 98. And it says, as crowds began to gather in Washington and were audible from the Oval Office, the defendant remarked to advisors that the crowd the following day on January 6th was going to be angry. This was again removed because we have language here of the defendant talking to advisors in the Oval Office, which the Supreme Court is saying is, protected. So that information was removed, and then we've got 99, 100, 101. These are all the same here. 102, so again, we have at 11:15 a.m., which matches here at 11:15 a.m. So number 102, 103, this language is all the same. And then we have paragraph 104 for 86. So you can see there's been a big cut of about 20 paragraphs here, everybody, right? Everyone sees that numerically, that we've cut out about 20 of our paragraphs. So we've got next beginning 11:56, and then that is next beginning at 11:56. This is the original here. And then they're going into more details. And then we have another piece that was redone. We get into the defendant's exploitation of the violence and chaos at the Capitol. And we have paragraph number, let's just say here, number 89. So 89 in the superseding indictment says, before the defendant had finished speaking, the crowd began to gather at the Capitol. Meanwhile, over here, this is what the original indictment says. Before the defendant finished speaking, a crowd began to gather at the Capitol. Thereafter, so all of this has been cut. Thereafter, a mass of people, including individuals who had traveled to Washington and to the Capitol at the defendant's direction, broke through barriers, cordoning off the Capitol grounds, and advanced on the building, including by violently attacking law enforcement officers trying to secure it. So this last piece has been cut from the original indictment. All right, and then we have this down here that is pretty much the same. These paragraphs are the same as well. We have another missing paragraph down here. We had 12, 22, 24, and then 1 minute later at the Capitol. So this has been all the same. And we've got one paragraph here that was a little bit different. So number 114, let me go ahead and pop you back over to the original. In the original indictment, everyone, this paragraph has been removed. The defendant repeatedly refused to approve a message directing rioters to leave the Capitol, as urged by his most senior advisors. Again, this is because of that immunity decision, including the White House counsel, a deputy White House counsel and chief of staff, a deputy chief of staff, and a senior advisor. Instead, the defendant issued 2 tweets that did not ask rioters to leave the Capitol, but instead falsely suggested that the crowd at the Capitol was being peaceful. And then we have these 2 tweets down here. So in the original indictment, this has been removed out of there. All right, that's been cut. Then that takes us to, let's see here. That takes us, then we're back to, here, we're back to paragraph 119, and then we just have a subparagraph A that's been removed. So all of the rest of these paragraphs are the same, except they've removed subparagraph A. Here we go. So this is what's been removed. The defendant, through White House aides, attempted to reach 2 United States senators at 6 p.m. This has been removed, so that's gone now. Then the next up, we've got the regular paragraphs. These are all the same language, with the exception of paragraph 124, which has also been removed. So 124 has been removed. The defendant and his co-conspirators committed one or more of the acts to affect the object of the conspiracy alleged in the above paragraphs, set out here. That paragraph has been removed. All right. And then next is getting into the counts. All right, so the counts, as you can see here, and I can get both of these, I think, in frame. This is the superseding indictment. It's exactly the same as the original indictment, with the exception of which paragraphs. The paragraphs have changed because they've cut about 20 paragraphs out. Number 3 is also the same. So count number 3 in the original is here. Count number 3 in the superseding is the same. And then that takes us to count number 4, which is, again, the exact same, conspiracy against rights here, and that language is exactly the same. All right, everybody. So I think overall that's a pretty fair overview of what was cut and what was added. Again, there was a really big chunk there that I did not review, but you can go through and take a look at those 20 paragraphs if you're wondering exactly what that language was. So again, that language was specific to the DOJ, the Department of Justice, and his discussions with his vice president, so the Mike Pence. Right. Yeah, I've lost track of how many times he's been indicted. I've lost track, everybody. I'm uncertain. So the big piece here, again, with the superseding indictment, everyone, is in the takeaway, the take-home point is that Jack Smith and his team have gone through the original indictment and they have cut anything that could possibly be questioned regarding presidential immunity, and they've just cut it out because they didn't need it. There's so much information in the indictment. It just wasn't necessary. So they added a few things to kind of clean it up, and then they cut away other things. How do you think these changes might affect the case? I don't see how this will fundamentally change much at all. Because there were so many different ways of showing the different acts, the only piece in here that I think really got left on the cutting room floor has to do with this question of asking the Department of Justice, all of that kind of hinky business where they said, where co-conspirator 4 was involved in saying, hey, let's ask the Department of Justice to give this memo saying that we've been looking for fraud and we've actually, we're concerned about it. So all of that kind of tap dancing around that was done with co-conspirator 4, that's all gone. And that has to do with the attorney generals, deputy attorney generals, and kind of that situation where they're like, wow, if you guys don't simmer down, we're going to all resign. Does everyone remember that? I mean, that's huge. But it's unnecessary to prove the counts charged. It's just not needed because they have so much other information. It's just not necessary. And so I can see why they cut it. I mean, it has definitely a big star quality to it, but as far as legal, I don't think it's needed. Will Trump be arraigned again due to the superseding indictment? Good question. I don't believe so. I don't believe we'll have that. Oops, puzzle piece, everyone. Hold on one moment, please. I don't think we will have that again. In Florida, we had another arraignment because we had a superseding indictment that included more defendants. Another defendant was added, De Oliveira. So we had an arraignment included there. But here we've only got Trump, so he's already had his arraignment. I do not believe we will have another one. I could be wrong, but I don't believe that we will need it. Do you think that the case will be removed like Florida due to Jack leading it? No, not at all. And, yesterday we went through Jack's reply brief on his appeal regarding special counsel. And, so the effects of the decision that Cannon made regarding special counsel would just be absolutely devastating to the entire Department of Justice. I mean, maybe that's one of the things that she didn't realize was how this would completely gut the Department of Justice if it actually were to stay in place. So it's not just about one case in Florida with Mr. Trump. It's about tens of thousands of employees. So, hopefully, hopefully the appellate court will get that sorted out. What's next in this case? So, great question. Now, by the end of the week, both parties are supposed to give their updates on their status of the case. All right, so Jack's way ahead. He's like several days ahead of schedule here, or ahead of schedule, by filing this. Both parties are supposed to tell the court what their status is by the end of the week. So I'm expecting to still see a status report coming in from Jack by the end of the week from his team, as well as by Mr. Trump's team. So we should have a status report from both sides by the end of the week, and then we have a conference coming up with the judge. So those are the next few steps. It's going to be busy. Yeah. Potentially every agency could be effective, canons upheld. Exactly right, Mary. Exactly. It's not even the DOJ. It's every kind of when authority is given to the head of an agency to have extra help come in, there's going to be a problem. That's what the problem is with her decision. Like if she wanted to figure out a way to carve it out so that Mr. Trump's case didn't go forward in Florida, I feel like there were easier ways to do that. Like there were easier ways, I think, to get the case dismissed than to, kind of drop this explosion on the entire executive branch. Like that's one of the problems with her decision, is that it's just so far-reaching that if it were to stay in place, it's like, wow, that's going to be a mess. Can you explain the status report? Sure. So Judge Chuck came in and she hit the ground running fast when she got this case back a few weeks ago, everyone. She had said, I want status reports. She had done 2 orders denying the motions to dismiss. She had just hit it, and she's like, we're going to take care of this. So what she wanted was she wants them to put together what's the status of the case? What do they think needs to happen in the case? Where are they at in discovery? Where are they at in their motions? What's going on here? And then the conference is just, rather than a hearing where you're presenting evidence and you're trying to argue something, a conference is when you're just talking it out. You're talking through like, well, where are you at? Where are you at? The judge is saying, well, this is where I'd like to be. This is where I see us in 6 weeks. Defense is saying, I don't see that happening. And, the prosecutor's like, sure, that sounds great. Let's do it in 3 weeks. It's just a chance for all the parties to get together to really talk through how the case is going to look, and put together when those hearing schedules should be, and how that's looking for them, what kind of motions they still plan to file ahead of time. I mean, are we going to have motion to suppress? What kind of other motions are we going to have going on as we're pushing through and working through this immunity question? So that's what she is meaning by status conference. Setting procedures moving forward. Exactly. And also to get some idea, too, like defense, what are you planning on filing 10 more motions to dismiss? Or whatever, like just to get some idea of what's going on. Do you think we'll have a mini trial? So, I have been using that term mini trial as a way to try to explain evidentiary hearings. And perhaps that may not be the best terminology to use, because we have pretrial evidentiary hearings all the time. They all happen all the time, all the time, all the time. It's not unusual. Here, we're going to be having some evidentiary hearings in order to determine both sides are going to argue this is covered by immunity, this is not covered by immunity, and they're going to argue it back and forth. And in order to do that, they're going to need to have a hearing. And it's going to feel like a trial, but in the end, it's a pre-trial evidentiary hearing, and then the judge will make her decision at the end of the evidentiary piece of it. So if you want to call that a mini trial, that's fine. That's fine. And I've been calling it that. But we're not having any kind of finding of guilt. What we're having is the judge determining what's going to be covered and what's not going to be covered, so she can come back in and decide what evidence will be allowed during the actual trial itself. And that term is being used constantly. No, it's not just you. That term's being used across everywhere. Are we going to have mini trials? That terms, everybody's using it. So that's why I want to say when I'm saying a mini trial, I'm using that just completely interchangeably with evidentiary hearing. And yes, it's very possible we're going to need it. I don't think we're just going to be able to have oral arguments on immunity. I think we're going to need to prove some things to the judge one way or the other, and she's going to need to make some determinations. So we can call it a mini trial, we can call it an evidentiary hearing. Both of those I think would be appropriate. What would the timeline look like? Now, that's a great question. I don't know. That's one of the things with the conference that they'll be able to determine, because depending on what the format of the evidentiary hearing is going to look like, will determine how long it's going to take. So that I just have no idea. Yeah, I don't. Soon I think is appropriate, Eric. I think soon is correct. I don't think Judge Chutkin is, it was Jack that requested the continuance to move this another week, or another couple of weeks. She was ready to go last week. She was like, we're going to have a hearing in 2 weeks. Get ready. We're done. and Jack was like, I'm sorry, Judge, can we have a little bit more time? So I think it was Jack that was requesting a little bit more time, but she's ready to go. I think she's ready to get this done and off her docket. And I think any of the judges who are dealing with these cases are ready for that. But they want to do it in a way that is appropriate and legal, so it's going to take some time. Oh my goodness. Yeah, I would say she's not playing exactly, VC. Oh, that's the perfect description. Yeah, Judge Chutkin's not playing around. She's like, this has gone up to the Supreme Court. It's come back down. It's in my lap. Let's get it done. Let's get it done. Yep. So without a doubt. Yeah, I'm not really sure what's going to happen with Judge Cannon at this point. This, honestly, everybody and I continue to read through her decision today so that I could spend some time going through it again and reading through it after reading through Jack's brief yesterday. I mean, she is just so far out of her authority that it could be sanctionable. It's possible. I'm not the one that decides the sanctions, but I believe she has way overstepped her authority, like way far. And again, the more that I read her decision, the more I feel confident in saying that this could really be a huge hit that she takes. Or it could be nothing. I mean, again, nothing is, everything's kind of wonky in the world of the law right now, but that's my humble opinion. Presents evidence related to official acts. Does that open the door for Jack to do the same? Yeah. Yeah, and that's how our hearings work. And our hearings are a little bit different than our trials. Our rules of evidence are different as well. What's allowed in, what's not allowed in. And also, public access is different during our hearings as well. So we're not going to have the kind of access that we've had in Georgia with the RICO case, which is amazing. Georgia's just like an open book. They're like, hey, here's a courtroom, come on in. We're not going to see the same thing in DC because we're in federal court, and they just do not do that with allowing the public in. So we're not going to see the same thing, but it's going to be a little bit different standards of evidence. Would it be necessary with this revision? Great question, and I'm not sure. I think Mr. Trump will push for it. I think he'll push for the hearing because it makes everything last longer. It delays everything by going forward. The judge, on the other hand, might say we need to have a hearing to make sure this is clear cut. And the Supreme Court, one of the big points that Roberts was saying was, no one's really even asked these questions or had a hearing on any of this, blah, blah, blah. So I think Roberts was kind of, can you guys do hearings and then let us determine whether or not you did your hearing correct? He was kind of schwarmy about that. So I think I think she's going to want to do a hearing. That's the feeling I got from his decision was they all were like, you need to do some hearings. We need more information. We need a bigger record to make our decision off of. So I think that may be what she's going forward on. Yeah. Yeah. Yeah, it'd be fun to see if he's got evidence. I've been waiting. I've been, watching Mr. Trump's trial for a while now, and I've been waiting for any evidence of anything. And I've yet to see it, but I'm ready to see it. When it happens, we'll see. Thank you so much. Oh, you're welcome. You're welcome. Of course, of course, of course. Unlimited supply of spoons. Oh, that's so sweet. That's so sweet. Yes, well, we refill and do what we need to do. So, yes, did not the Supreme Court ruling block investigations to whether or not the act is official? No, no. And, the decision, if you get into the weeds of that decision, they're saying clearly, we want you to figure out if it's official or not official. Here's some suggestions, which I thought was interesting, and here's a couple of examples of what's written in the Constitution, but we don't have anything firm we don't have anything to hang our hat on, so we want to see something. Well, you are welcome. Did a revision make the hearing a moot point? I think it's definitely going to, he's trimmed it. He's trimmed the fat, and I think he's definitely being more strategic, which you need to do. And this case has a ton of evidence, so it's not that he is going to lose anything that he needed here. So, tea break. Thank you for that. Views as to how Judge Cannon passed the freaking bar. She's not the sharpest tack in the box. We don't have to be the sharpest tack in the box to pass the bar. You just need to be a tack in the box and know how to take a test, in my opinion. Oh my goodness. Can their immunity decision be over in the future? Yes. So it would take an act of Congress. Now for presidential immunity, because it is a presidential piece, rather than it actually be done by statute, like the marriage statute, this would need to be a constitutional amendment. I think there's one being proposed actually. This would take a constitutional amendment to clarify immunity for the president. And that's not a bad idea, really. Not a bad idea to clarify that stuff. Use decision by the Supreme Court be overturned. So the Supreme Court can overturn its own immunity decision, yes. So let's say the two justices who have articles of impeachment against them were to be impeached and replaced, and then the case somehow a case made it up, maybe like the appeal of one of these hearings made it back in front of a new Supreme Court, they could overrule themselves. It's absolutely possible. Yeah. Thank you for all you do. Oh, yeah. Oh, thanks for all the gifts. Oh, my gosh. Yes, thank you so much. Oh, my goodness, everybody. I tell you, the sheer paper quantity at this point is just... I recycle responsibly, all right? I'm very careful. I just wanted to let you know. Very careful with my recycling environmental policy here. So, for sure. So with that, everybody, we should be seeing something else again, a filing from both parties. We should see something by the end of the week again, a status update regarding this case in DC, and then we will see the status conference coming in. So we should see another filing. I was not expecting this today, which is Tuesday, because yesterday we got our brief for Florida. So we will see more later this week. The next few weeks are going to be busy. We've got arguments in all kinds of cases. We've got oral arguments all over the place. We've got copyright cases coming in. We've got the Carroll case is being argued. We've got all kinds of appellate cases going through. So the next few weeks are going to be kind of busy, everyone. So I'll keep you posted. Jack had plans for Labor Day. I think you're right. I think he was like, I got stuff to do. Oh my goodness gracious. So yeah, he was definitely working hard, working super hard. So with that, everyone, I believe the immunity decision was correct. Well, and fair enough, Paul, fair enough. I can't say that every single word in the immunity decision was incorrect, but I do not agree with their interpretation of precedent. But with that, I will go ahead and sign off for tonight, everyone. I wish you all a wonderful rest of your evening. I will be back as soon as I can, and if something big hits again, I will come on as soon as I can. This particular live, I've got three actually lined up to go up on my Tube of You, but I will post this one tonight. So you can expect this one to be up in just a couple of hours for anyone who may have missed the beginning part of it. So yes, my flannel, because I'm kind of off the clock. I'm off the clock, but I came back on. So so I will post this up on my Tube of You in the next few hours for anyone who is interested. But with that, I will sign off for tonight, and I'll be back again when the next big thing hits. So take care, everybody. Thank you all for joining me. And as always, thank you to the moderators. You are amazing. I'm so grateful for you all. Take care, everyone.